Welcome everyone to our webinar on pay for delay. Michael Harary, I'm Director of Litigation Partnerships here. We work on finding the right partner for many of our cases. I practiced for about 10 years before joining Darren. I've been about 3.5 years. Tany is joining me. Maybe just take a moment to introduce herself.
Thanks, Michael, and welcome to everyone who's joining us today. My name is Tany Sinai. I'm a patent attorney, and I'm a senior IP advisor here at Darrow. I've worked for many years in biotech and biopharma companies, where I've built and led IP departments and managed the full range of intellectual property assets, from patents, trademarks, trade secrets, and teaming up with R&D, regulatory, and business teams to really develop and execute IP strategies across the entire life cycle of a product, from early stage innovation to commercialization. And very excited to be here today to be talking about pivotal.
Awesome. So the title is Pharmaceutical Antitrust Litigation, Actavis, the Aftermath and the Evolution of Pay for Delay. Maybe we'll start from the beginning and just like a quick practice overview of terminology. What exactly is pay for delay?
Okay, so before I start, I just want to say that pay for delay is a very different type of case that you see in the IP landscape. What works here is that we get sort of a behind the scenes look into how powerful patents really are in competition and shaping competition. So it all starts with a brand company who wants to introduce a new drug into the market. Now, when a brand does that, it's after investing millions of dollars in over many, many years in research, development, clinical trials, and meeting different regulatory requirements. Now, once they've done that, they really want to start getting a return on their investment. So the best way of doing that is being the exclusive supplier, provider of that drug in the market. That can be done with patents, because patents provide the owner with exclusive rights over the invention. And when you think about a drug, you can patent different aspects of it, right? You have the drug substance, you have the drug formulation, you have methods of using the drug, even a process of manufacturing the drug. So what the brand does is that they build this really broad patent portfolio around the drug so that competitors will have to wait for all these patents to expire before they can enter the market with their own version of the drug.
Yeah, and I think patents in general, there's a tremendous commercial benefit to them. So I think that's what helps create innovation. So at the start, patents are very productive and very helpful because it allows someone to say, listen, I'm going to invest into this and I'll have tremendous commercial investment.
Definitely. So they're actually used for the owner themselves because they know that they will have exclusivity over their invention. So usually what happens is that the generics have to wait out for all these exclusivities to expire. But sometimes the generics don't want to wait. And what they do is that they will file for FDA approval for their drug now, and they want to enter the market now, even though there are still patents listed on the drug. And this is possible because of the Hatch-Waxman Act, which really enables generic companies to challenge the patents that are listed on the drug and saying, you know what, the patents are either valid or will not be infringed by the generic version. Now, once a generic challenges patents that are listed on the drug, this triggers a whole process in which the brand can sue the generic for patent infringement. And this is where things get interesting when we're talking about pay for delay. Because, normally what you'd expect is these parties to litigate till final decision. But instead, in pay for delay, these parties settle. And the way that they settle is that the generic agrees to drop its patent challenges, delay its market entry, and in return, it receives compensation from the brand, which is odd, right?
Yeah. It's almost, hence the name pay for delay. It's interesting because, it's interesting because I think just to double click on that for a second, because I always think about like the commercial terms and the balance, because on the one hand, you have the patent protection to encourage innovation, right? But then on the other hand, you have rules and markets to allow for generics to combat against anti-competitive market control. So you need to have this balance where generics are allowed to enter in to bring down the prices for the general public.
Exactly. And that's exactly the point with the Hatch-Waxman Act. Because on the one hand, it's supposed to encourage innovation, but the other hand, it also encourages competition, fair competition. And, the question is, so why would they settle? I mean, they already started the process. And you have to look at it from both perspectives, from the brand side and from the generic side. Because, if you think about the brand, they want to keep their market monopoly. And patent litigation is risky. I mean, even if you have a strong patent, which in these cases they usually don't, but even if you have a strong patent, a patent can be challenged. It can be narrowed. It can be invalidated, entirely. So they don't want to get to that point, because losing a patent can really immediately, it's a huge deal. It will open the door for generic competition immediately. Yeah. And opening the door can trigger a price drop from 20 to even 90%.
If you lose the patent, it's not just one single generic company who brought the case. Then I think the floodgates probably open up.
Exactly. And that's exactly what we see happening. And we can see that if you have more than one generic on the market, the price drops dramatically. And that's monumental for a brand that makes so much money from being, throughout that term, just being the exclusive provider.
Yeah, I think I read a study, something along the lines like after the first generic, it's like a 40% drop. And then once there are multiples, you're talking an 80, 90% price drop, which is fantastic for the consumer, not so much for the company.
Exactly.
I wanted to just ask you a question about the not so recent case at this point. There's a pivotal case from the Supreme Court, Actavis. At the time, it was brought to the Supreme Court, and it really changed the landscape of pay for delay. I'm curious your thoughts on it.
On the specifically Actavis case.
Yeah.
So that case was a major turning point in how courts analyzed pay for delay cases. The FTC, the Federal Trade Commission, versus Actavis relates to. Well, before that, I want to kind of explain how it worked. Before Actavis, courts applied something that is called the scope of patent test. So under this approach, any agreement, any settlement agreement that falls within the patent term exclusivity and within the subject matter of the patents was considered permitted, was lawful, even if the brand paid the generic to stay off the market. And that is exactly where Actavis came in and changed all of that. We had Solvay, the brand company, selling androgel, and they had patents listed on the drug. And Actavis was the first filer, first generic to challenge those patents. So when Actavis challenged the patents, then Solvay automatically sued them, and then they settled. And Solvay settled with Actavis and later on with more generics by paying them millions of dollars to stay off the market for years. Wow. Now, the FTC challenged that agreement, saying it's anti-competitive. And the district court and even the 11th Circuit dismissed it. But the Supreme Court reversed that decision and said that these types of arrangements can violate antitrust laws. And the Supreme Court said that you can't just use the patent, the scope of the patent test, but you have to really look at these cases under a rule of reason and check things like, was there a large unjustified payment? Did it delay generic entry? And did it harm competition?
Yeah, I think once they shift to rule of reason, it opens the doors to actually take a hard look at what are the facts here. What transpired, what occurred, as opposed to the benefit going automatically towards the defendant and the patent company. Well, now we're bringing this into the realm of reason. Let's take a look. Let's uncover what happened.
Mm-hmm.
Yeah, I mean, what do you think? I know that was in 2013, I think. What do you think the single most important takeaway was from that?
I think the most important takeaway from the Actavis case was that patents are not a safe harbor for antitrust scrutiny. And courts really have to look at the economic reality of the deal. I mean, I think what was really an accomplishment here was for the court to recognize that these settlements aren't really about protecting innovation or settling patent disputes, but what they are is protecting profit, monopoly profits.
Yeah. So I would imagine at that point, the litigation landscape just shifted. It's not as if these actions or these harms stopped. It probably just now was more uncovered, was more concealed. Your thoughts on that? I'm curious if you think all of a sudden the magic went away, or now if companies started shifting into hiding in different patterns.
So that's like a pain point in this field, because you'd imagine that companies would stop, or maybe you'd see less of these actions. But knowing that the FTC and litigants are now looking for large unjustified payments, they just became much more, they changed their tactics.
Probably more complex.
Yeah. And what we've seen was that actually, instead of seeing large payments, which are easier to detect, they just moved on to non-cash transfer of value. And the problem was that these are much harder to detect when you're looking at.
I want to press you on that. I'm curious. What do you mean by non-cash transfers?
So what we've seen is that there are different ways of compensating the generic to stay off the market. You can see side business deals, AG agreements. AG is the authorized generic.
Okay.
One thing we haven't touched on is that a first generic that challenges the patents is eligible for 180-day exclusivity in the generic market. The only competitor that can compete with them at that time is the brand with its own version of the drug, and the brand introducing a generic version of its own. So what brands do is that they trade this authorized generic. And they do it by either agreeing not to launch their own AG during the period of exclusivity of the generic, or they offer that AG to another generic filer.
It sounds like the AG is like the sweetheart deal, right? If you get it, you have access to being the first level AG after the brand, and that's a coveted position to have.
Exactly, and it's actually a way that it looks legitimate, right? It's hard to detect, but it's a definite way of saying to the generic, to the competitor, here's a portion of the market.
Right.
We're
carving it out for you, essentially. Like here, we're giving you this great portion into the market that we're essentially authorizing. You're the single generic coming out first. You start at a higher price point, and you have access to the greater market.
Right.
Wow.
Right.
Now it's not cash, but it's other ways to add value into that company.
Yeah, and it's other than that, there are like other. It's not like the only way that you can also get shared marketing arrangements with the generic, supply contracts. You can even do quantity restrictions, saying to the brand, to the generic, you can enter, but then you can actually sort of manipulate the price there as well. So there are different ways of making these deals or disguising them as legitimate commercial arrangements.
Yeah, I guess nothing stops sometimes when there's commercial involvement. So I'm curious, what are we doing here at Darrow to help or uncover these type of things? Okay,
so understanding that these are harder to come across because they're subtle and complex. What we're doing is we're using technology. So at Darrow, what we're doing is really taking data science and legal expertise to identify violations at scale. So what we do is that we pull data from many different sources. We've got FDA records and patents and market data. And what we do is take all of that different data and create a full picture around a specific drug that we're looking at, for example. And once you have the full picture, you can really spot anomalies within it. So things that individually may not seem that relevant, when you have a full data picture, they really kind of raise red flags.
Yeah. Now, I won't ask you for a specific example because I know you have a live investigation to it. But correct me if I'm wrong. My impression is, well, you have one marketing sort of settlement that happens in one area. And then in a separate area, you have some sort of filing in a commercial sense. And in a third area, you have a patent litigation that's ongoing. So isolated, each one kind of gets lost, I would say, or kind of doesn't add up to anything serious. And that's probably what they're trying to accomplish. But I guess the use of technology is now saying, well, I have a data node here and a data node there, and they kind of seem non-related. But when I put the picture together, well, now I see what's going on. Now it's no longer just individual things. Now I see the whole scheme uncovering.
Yeah, so we're not just looking at individual cases, but we're creating these patterns, and you can see patterns through settlements, markets, even when you're looking at companies. And these patterns they repeat. Sometimes you can really kind of map them out.
Do you find that they repeat within the same companies?
Yeah.
Yeah, I guess that makes sense. I guess if one company is successful in this pattern one way, they may repeat it. I'm just curious, like, do you find that, brand name, Acme, do they do similar things with different drugs?
Well, you see that there's a repeated conduct of behavior within a company, and these things surface over time. So, a certain way that they acted in the past may just rise now. So it's hard to predict when they actually, if they had two different drugs and they decided to act upon them the same way, no one will know that until things will start to pop up and time goes by and then evidence accumulate. And only then you can see that there's actually a repeated pattern of behavior.
And I guess that's stemming back to how we started with Actavis. It's that rule of reason now. Well, now we're going to uncover and think of it in a different way than giving deference to patents. There was a recent case that I was following, the Forest Labs case. It was in the Second Circuit. And I think it was interesting there. It was dismissed. The case was dismissed in the district court, and then it was upheld on appeals. What I think was interesting there, it was dismissed because of factual or lack of factual findings. And I think it kind of goes to exactly what you're saying. It's not as if there's this free-for-all now in the pay-for-delay space, whereas the rule of reason will allow everything to go forward. Because you do see cases being dismissed. But it kind of really hones in on the importance of finding these different data nodes beforehand. And I think when you come into a litigation like they did in Forest Labs and others, with one piece here and one piece there, well, then I think you're still going to get dismissed in the courts. But I think what you're saying is really important in the sense of getting this picture, getting this entirety, this landscape, this pattern, will propel you to get past this motion, to propel you further on.
Yeah, and I think what we see here is that, having a single evidence or two evidence or three evidence is not enough to have a substantial case. You really, because you're building your case on factual evidence, you really have to have a strong case behind you, and just pieces of information that you don't know how to connect or connect by a really narrow kind of point of view is not enough, because you're going to be challenged,
right.
And you have to show that there was actually impact on the market, even if just by having the settlement.
Yeah, and I think it goes to the anti-competitive behavior. So now what you're doing is you're bringing the full picture ahead of time. Whereas you may in other areas say, well, I know I can do it just enough to get past the motion and then I'll find out more in discovery. That doesn't seem to work here. And that's really interesting. I guess I have a bigger question just in terms of technology. How do you, with respect to some of the privacy cases, those are very popular. You could see where technology lines up with the law. How do you find that technology still respects the legal nuances? I mean, patent law is a very complex and fact-specific area. How do you find that you're navigating that?
So our system it doesn't try to replace legal judgment. It acts as a discovery engine that really highlights these patterns and timelines and anomalies. And at the end of the day, it's really up to us, the legal team, to interpret those findings and interpret them, in light of the case law, the statute, and of the facts. You can't have the system do it. The system just highlights where to focus, and then we dive in.
Yeah, because patent litigation or at least understand these patents are very complex and very nuanced.
And they're very different from one another. That's another very important piece.
Do you have an example of that? I'm curious.
I
I guess each one is so nuanced in the sense of
They're,
like you have
they're so
patent.
nuanced. Yeah.
Yeah, I
They're,
always within the patent, like you mentioned at the start, you have patents for the specific drug, but then you also have patents how it's being administered, right? And you have how it's being stored. So all of a sudden you say, well, I may say, well, this one aspect of a patent seems a little bit off, but it may have other aspects that are not. So I could see where their technology can be red flagging the wrong things, and how important it is to have an experienced patent attorney actually dive down and look at the case.
yeah, because when you think about it, the companies list a lot of patents in the FDA on each drug, and that is actually what deters competitors. They see so many patents listed, and they see, you know, the exclusivity running through 2030 or 2040, and that deters competition. But
Or down the road, I'm not even going to bother, right?
yeah, but what you really have to see is that what do those patents cover? Are they
Right.
related to the drug? Should they be there? So there are different ways of looking at these cases and really understanding what patents. I mean, what is the scope of the patents that we're really dealing with?
You know, these patent companies invest a lot of money, and they really do the best they can to hold on to that monopoly. And it's unfortunate to the consumers. And I'll harp back to that point of the generic pricing, where when you have a generic enter, it's about 40% drop. And then when you have multiples, it's almost 80, 90. And that's a huge amount of money for the consumers. And these are not, unimportant drugs. A lot of times they often deal with cancer drugs. And
These are life-saving drugs, and that's where it really hurts because you
yeah,
know who is down the line
yeah.
and who needs this specific medication, and these companies use that for their
Yeah,
own.
one of the many things about paper delays is that how much it aligns with, I think, with most people's common sense and missions in life, in the sense of you have life-saving drugs that are being charged at 300% of what they could have been had a generic entered, and then you have individuals who are suffering both now financially in addition to their physical suffering, and that's what the market is supposed to do, right? It's supposed to allow generics to enter to bring down the price for the benefit of the consumer, and that's what these paper delays are really inhibiting.
Right.
Yeah. So we say we have a question came in. Take it. Here it's, do you think there will be a stream of cases? That's an interesting question.
I think we already seen a stream of cases starting with Actavis. I mean, since that came out, both the FTC and private plaintiffs started to file pay-for-delay cases on past cases, not just cases that came afterward, because cases were then dealt under the rule of reason.
Yeah.
And we definitely see more and more cases submerge because these cases, you can actually identify them as time passes. When you see generic companies enter, then you see this lag period between when they should have entered till now. So, yeah, I think we've already seen a lot of cases filed, and we'll probably see more.
I would imagine the stream of cases really comes down to 2 points. One, this behavior won't stop, right? You'll always have companies with its huge profits and huge commercial incentive to try to do this. So I don't think you'll see, because the rule of reason is now the accepted law, I don't think you'll see companies say, well, then I'll stop. I think you will always, unfortunately, have bad actors. And I think the second point is, and this is where technology really helps, and you see it across other areas as well. I just don't think we've applied it to the antitrust world yet, is you have systems built. You have AI, you have technology that is building models that continuously monitor and uncover violations. It's not creating violations, it's uncovering them. And unfortunately, they exist. And I think why we'll have a stream of cases going forward is because there's a huge market in the pharmaceutical market. It's tremendously profitable. You will continue to have bad actors, and they'll just get more complicated, and they'll probably get smart about how they cover it up. And the more we develop our technology to uncover this in a steady way, well, then you'll have predictability. And I think that's important, because I think it's important to know we'll have a predictable stream of these type of cases coming forward for everyone. I think it's for firms to plan, for FTC, for consumers to know that somebody's looking out for them. So the more, we work on these tools collectively, I think you'll see the stream of cases come through.
I hope so.
Yeah, I think so. Um, okay, I think that's all we have time for today. Thank you so much for listening. I hope you found it interesting. If you are interested in working on some cases, anything in the antitrust space, or hearing more about what we do here, please reach out. And we'll look forward to speaking more. Thanks so much. Have a great day.
Bye.